Hey, yo, folks, and welcome to something that is long overdue. It is an update on the Delphi case. I've been following that case since, or another case I've been following since last year. And now the defense is throwing somewhat of a Hail Mary. It is called a precipice for determination. And what it does, it makes another judge take a look at certain things in the pre-trial, in the motions. Now, if you're new to this, which half of my subscribers are, let me give you the elevator pitch. Ooh, I have to think about this while I play the intro. Welcome to the show. All right, Judge Gull, or as I very affectionate call her, Judge Gull, has already been reprimanded by the Indiana Supreme Court pre-trial. Why, would you say? If you're completely new to this, she disqualified the defense attorneys without an actual hearing, without checking the evidence against them, without anything, because she does not like the defense. The defense has brought forward an alternate theory to the state's case. And the state's case is, well, interesting, so to speak. The investigators in the Delphi case lost the first 70 days of recordings. I'm not joking. The first 70 days, including but not limited to interviews on paper, on video, or both of two people of interest that since have changed their story allegedly radically about their whereabouts at the time of the ending of the two girls, if they knew, or one of them, if he even knew or seen her. One of the persons of interest is one of the victim's boyfriend's father. And Judge Gull, under her watch, Mr. Richard Allen has been held in a state prison with limited resources, with limited access to the outside world, with limited access to his own lawyers. In one of the meetings, Mr. Allen was put in a small steel cell inside a room, shackled against his stomach. But still, Judge Bell says that's not limited, because he could meet with his attorneys. Yeah, but he couldn't take papers. He couldn't, more or less, couldn't sign papers. I mean, this is so extremely bad that I made a 5-part series with Mo in the Deep End. I will link it in the description so you can get a feel about how really bad it actually is. But when I say it's bad, it's really bad. And Judge Gull thought that disqualifying that first set of lawyers and bringing in 2 other lawyers would put an end to this alternative theory. The other set of lawyers got the discovery papers, met with their client once, and then reaffirmed the previous set of defense lawyers' alternative theory. Then the Indiana Supreme Court reinstated the previous ones. They did not disqualify Judge Gull. For some odd reason, they chose not to, which only shows how hard it is to get rid of a judge. Think about that when you think about Judge Glanville and how hard it will be to get him yeeted off the bench. Now, what about this Hail Mary? This is the Hail Mary. State of Indiana versus Richard Allen, Precipice for determination whether a ruling has been delayed beyond the time limitation set forth under Trial Rule 53.1. Comes now the accused, Richard Allen, by and through counsel Andrew J. Baldwin, and respectfully files this Precipice for determination whether a ruling has been delayed beyond time limitation set forth under Trial Rule 53.1 as follows. Here is the part of that rule. 53.1 E states, upon the filing by an interested party of a Precipice to specifically designating the motion or decision delayed, the clerk of the court shall enter the date and time of the filing of the Precipice. Record the filing in the chronological case summary under the cause, which entry shall also include the date and time of the filing of the Precipice, and promptly forward the Precipice and a copy to the chronological case summary to the Chief Administrative Officer, CAO, of the Indiana Office of Judicial Administration, IOJA. Richard Allen is an interested party because he is a party in this case. He is the defendant, the accused. Richard Allen specifically designates the following motions or rulings that have been delayed as follows. On March 13th, 2024, the accused filed, quote, Richard Allen's third Franks notice and request for a Franks hearing based upon newly discovered evidence and request for findings of facts and conclusions of law upon any ruling on this request. In bold. Said motion is not a repetitive motion as it contains completely new allegations and new information not previously alleged in previous Franks motions. Now, you might ask yourself, what is a Franks motion? Hold on. Let me... No, that's the wrong page. Here I am again, not believing in editing. Dun, dun, dun. Dun, dun, dun. This is from Hills at Law PC. A Franks hearing is a court proceeding wherein the court is asked to determine if the police officer involved lied in obtaining a search warrant. Possible grounds for a Franks hearing. A trial court is obligated to conduct a Franks hearing only if the defendant makes a preliminary showing that, 1, the affiant knowingly and intentionally or with reckless disregard for the truth included a false statement in the warrant affidavit, and 2, that the alleged false statement was necessary to a finding of probable cause. In short, did he lie? Did the cop lie? Or she, for that matter, in order to get a search warrant? And the defense in the Richard Allen case, in the Delphi case, strongly suggests they did. Simply, well, one of the reasons is now, there have been others, that they lost 70 days of interviews, among them, and but not limited to, people of interest's actual statements who are now lost forever, which the defense, if this goes to trial, can't cross-examine if these two people who are, according to the defense, are the actual culprits. how they have changed their story. It is impossible because the investigator, by recklessness, by incompetence, or by other means, lost the recordings. It's a much longer list, but for the sake of having it compromised, shorter, let's stay with that. On April 29, 2024, the accused filed defendants Richard Allen IV, Frank's motion based upon... that's a repetitive. On May 7th, the court issued a pleading indicating that, quote, defendants' third and fourth request for Frank's hearing will be ruled upon and not set for hearing unless necessary. For it has been 119 days since the defense filed its third Frank's notice. It has been 72 days since the defense filed its fourth Frank notice. It has been 64 days since the court claimed that it would be ruling on the third and fourth Frank motions. The defense did file for recusal of the judge on May 17, 2024, and the judge denied said motion on May 31st, 2024, totaling 14 days from the filing of the motion to the ruling on said motion. Even after the 14 days, which the judge could not rule on any motions due to the recusal motion, are factored into the calculation of time determining whether the court has violated the requirement of Indiana Trial Rule 53.1. Both of the Frank motions would still fall significantly outside of the time requirements mandated under Indiana Trial Rule 53.1. It states, in the event a court fails for 30 days to set a motion for hearing or fails to rule on a motion within 30 days after it was heard or 30 days after it was filed, if no hearing was required, upon application by an interested party, the submission of the cause may be withdrawn from the trial judge and transferred to Supreme Court for the appointment of a special judge. There is no hearing required on the motions related to the third and fourth Frank motions, but the court has still not ruled on these motions, even though more than 30 days have passed since they were filed. This is an reoccurring event in the Delphi case. Everything is late. Every piece of discovery, the prosecution fights tooth and nail to not hand over. For instance, the prosecution knew 70 days of recordings were gone for months before they handed it over to the defense attorneys. For months. In clear violation of every rule there is when it comes to discovery. But the judge doesn't care. She simply does not care. It should also be noted that it took the trial court 127 days to rule on the first Frank's motion, filed in September of 2023, and ruled upon January 22nd, 2024. And then finally ruled on said motion only 4 days after defense counsel were reinstated to the case, the afternoon of January 18th, 2024. Yes, as I said, she first disqualified the original set of lawyers. The second set of lawyers reaffirmed the first set of lawyers, and then the Indiana Supreme Court forced Judge Gull to reinstate the original set of defense attorneys. So this has already been up in the Indiana Supreme Court, who just slapped her on the wrist instead of putting a foot up her ass. Let's stay calm. Before defense counsel had the opportunity to find a similar trial rule 53.1 request for the court's delay in ruling on that motion. None of the exceptions set out in the Indiana trial rule 53.1b are applicable. Defense counsel is requesting the clerk of the court, pursuant to Indiana rule of procedure, to enter the date and time of the filing in the clerk's precipice book, record the filing in the chronological case summary under the cause, and promptly forward the precipice and a copy to the CCS to the Executive Director of the Division of State Court Administration. Indiana Trial Rule 53E Part 2 states, If the CAO determines that a ruling or decision has been delayed beyond the limitations set forth under Trial Rule 53.1 or 53.2, the CAO shall give written notice to the judge of the cause, the clerk of the court, and the clerk of the Supreme Court of Indiana that the submission of the case has been withdrawn from the judge. The withdrawal is effective as of the time of the filing of the precipice. The clerk of the court shall record this determination in the chronological case summary under the cause and provide notice to all parties in the case. The CAO shall submit, not maybe, not under the judge's discretion, shall submit the case to the Supreme Court of Indiana for appointment of a special judge or such other action deemed appropriate by the Supreme Court. Wherefore, the petitioner by counsel pursuant to Indiana Trial Rule 53.1 respectively files his precipice for determination whether a ruling has been delayed beyond the limitations set forth under Trial Rule 53.1 and requests the clerk of the court to enter all of that. Respectfully submitted, Andrew J. Baldwin. And here's the certificate. And what makes this a Hail Mary? Well, one of the last sentences there, anything that the Supreme Court deems necessary to apply to this. They might just slap her on the wrist again and said, hurry up. Or they get up to get the F out, you words. But it is a Hail Mary. The only thing that might make the Indiana Supreme Court make a harsher ruling is that they already had to tell Judge Gull to follow the law once before. And clearly, she does not listen. She does not listen because she is another judge. It's her court. Screw the law. It's my court. I can do what I want. Meanwhile, Mr. Allen has been in prison, not jail, prison, for what is it now? 2 years? More? More than 2 years. Seriously, it's infuriating to see because we know there are good judges, we know there are good prosecutors, we know there are good cases out there. But they are being overshadowed by the amount of people being judges that simply should not ever be allowed to practice law. All right, folks. Thank you all for listening. I will try to give more updates as the Delphi case moves along. It is set for trial in October, I think. Early October. I will visit Delphi, Indiana in August when I get there. So that will be interesting because the two interested people of interest in this are so-called people of Acer faith, as in the old Scandinavian gods. And from what I've read about their specific branch, they are diaper Nazis. They are, oh, this is cool, the old Scandinavian, the Norse gods, let's do that and run around the fire and circle jerk each other, and I don't know, I don't care. They are pathetic people, okay? Pathetic people. All right. End of rant. Okay. Again, thank you all for showing up. Thank you for allowing me to do this. Hit the thumbs up, subscribe, you know all the things. And I will see you in the next video or stream. Hug your family, folks. Unless your family is crap, then screw them and give the love to the people who deserve it. Bye-bye.